If you don't know who I am, my name is Tyler Sklar, and I've been working with a team of fellow students to file several cases to the Supreme Court touching various things such as apportionment, election fairness, and overall civil rights to ensure that this student government stays as democratic and pluralistic as the Constitution promised to the student body. During the last semester, we submitted a case challenging student body statute 322.51, which is part of data, apportionment for data, for violation of the anti-discrimination clause by how they collect data. And instead of reviewing the constitutionality of this of our case or the statute, the Supreme Court decided to not do anything. Their response is that they say that they can no longer determine the constitutionality of any statute according to how they interpret the Constitution. In my opinion, that is a complete violation of several legal doctrines and 17 years of precedent. I mean, we learned something as basic as this. It's in AP US government, stare decisis. It's a legal principle that makes us stand by things decided and emphasizes the importance of precedent in the judicial decision-making process. This is to ensure that the judicial branch works as intended to hold the other two branches accountable and ensure that the rule of law stays in place for our student government. The legal system must function for a stable democracy. As for me running this, I cannot say with full confidence that this student government is a legitimate government because the rule of law and the legal system is at risk because they decide to withdraw from reviewing any constitutionality of any law in the future according to this case. I mean, we filed a case in response to this to appeal this decision and have all the justices recuse themselves, which might be the first in the entire student government history. We've submitted over 17 years of precedent. There's over possibly like 20 cases that we have submitted. And just for emphasis, the earliest case on here is from 2007. That is how old a lot of these cases go. There's cases on the Atwater Act. There's cases on more of the Atwater Act. There's cases on dilatory motions. There's cases on several statutes. I mean, these are all cases that the Supreme Court has decided to review constitutionality. Instead of doing that, they decide to hold their hands up and say, no, we're not going to do this. We're not reviewing constitutionality. That puts the entire legal system at risk. And moreover, not only have they decided not to follow basic legal principles, they have violated their own rules and practice procedures for the entire fall semester by not holding a single oral argument in person. I mean, members of the Journal Student Body and Student Body President can oppose petitions, and they can establish jurisdiction by filing a counterpetition within at least 3 school days prior to a scheduled hearing of our petitions. They didn't allow anyone to do that from this Senate, the executive branch, or anywhere else because they decided to just, review the cases online in some uninformed area. That is not transparency, and that is a direct violation of these rules and procedures. And they also did not respond to our petitions, our latest petitions, within 14 days. So, in response to this, not only did we file a case for recusal, for all of our cases, I submitted an email identical to this, requesting them to recuse from all these cases. We're hoping that the Supreme Court will actually follow their due diligence and actually reconsider all our cases and follow stare decisis and actually view the constitutionality of everything we put in place. I'll report more on this in the upcoming weeks. Thank you.